So the next bit, excitingly, is the legal essentials, which I'm sure is why you're all here today. I realise that's very yellow, which is also quite large, isn't it? Okay, so I am just going to talk to you. My name's Charlotte. I'm a partner in the disputes team, focusing on IP. So today we're just going to have a little look at the decision which was handed down in January this year. So it's not recent as such as in the last few months, but I think it's still definitely worth a mention. So in brief, Thatcher's Cider, which you probably all know, began selling a cloudy lemon cider in February 2020, and they registered the trademark, which is essentially the wording and the images of the lemons, which you can see there. So they're on the left. And then in the slightly varied form on the can. So the sales were great, and it was known to be a really strong performer for Thatcher's. So they've got some real emotional loyalty there, picking up on the theme from earlier. So in May 2022, Aldi launched Taurus Cloudy Lemon Cider, which is shown on the right here. It was launched as a seasonal variant and intended to sell out within a period of months, which it did in about 10 months. Before that, in September 2022, Thatcher issued a legal claim. This was against Aldi for infringement of their trademark on 3 grounds. And that was that their use of a similar sign created a likelihood of confusion. It took unfair advantage of the reputation of the trademark and also amounted to passing off. Of particular importance was the fact that Aldi had used Thatcher's product as the benchmark for both taste and packaging and did no marketing of their own in respect of this product. So in 2024, the High Court found in favour of Aldi and said there was no infringement. Thatcher's, unsurprisingly, appealed to the Court of Appeal, but only in relation to their claim that Aldi took unfair advantage of the trademark, which is an infringement under Section 10.3. In December last year, the Court of Appeal reversed that decision and found that Aldi had taken unfair advantage and therefore infringed the mark. Now, this is significant for brand owners because it shows it is possible to prevent lookalike products in circumstances where similar packaging is used by the infringer to boost their sales to the detriment of the original brand, even if customers haven't been confused. What's important, though, for brand owners is to take proactive steps to register trademarks for their logo and the packaging. It's clear that they now have a route to succeed, which doesn't require them to rely on a claim in passing off. And passing off requires you to show that there is a likelihood of confusion, which sometimes you can't do. It's notoriously difficult, especially in relation to the discounters, because you're deemed to know that you're buying an alternative to the original brand. You know you're in Aldi, you know you're in Lidl. So in short, bringing a trademark claim is likely to be more straightforward, and the latest decision of the Court of Appeal is a helpful warning to businesses looking to copy others. So for all businesses starting out, it's important not to disregard trademark protection as a nice to have, but consider it at an early stage and register the product packaging as soon as possible. For those businesses bringing out new products at pace, it's important to keep trademark protection up to date and under review and ensure that the protection that you have is in relation to the products that you are currently selling. So should someone copy the next hero product, you're able to stop them. Over to you. Oh, let me just change this slide. Ta-da.
Thanks, Charlotte. I'm Ian. I am a partner in the IP team. Question to the audience. Why have I got a monkey on the slide? Anybody recognise the monkey? Well, the other ones do. Well, one does, Ericsson does. A few years ago, there was a lot of interest in who owned the copyright in the monkey selfie, because the photographer had handed his iPhone to a monkey, and the monkey had quite a lot of fun and done quite well and produced these pictures. They went viral, and the photographer then tried to sue lots of people around the world saying, it's my picture. Intellectual copyrights are quite prescriptive in how they arise, and you need a human author. Hence why I'm talking about AI. Because basically, if you're using AI to create creative copy, you probably don't own it. And so that might come as a bit of a surprise to you. And there's a case that's going to be it's already been heard, the judgment is going to be handed down in the next month or so, Getty Images versus Stability AI. And key to that case is the way that the image, and if we do stage left, so that's a sort of blurry image, that's the Stability AI, pretty terrible, but they asked for a football scene, and that's what the AI tool generated. And Getty Images were able to demonstrate that Jordan Henderson, and I think it's Ericsson, I might be wrong on that, but basically it was copied from there. And so what it's going to decide is whether or not an AI tool in itself can infringe. And so the expectation is, all the topics today have raised AI as an issue, that there's a risk of using an AI tool in an infringing way. Now, I'm not going to sit here and say don't use AI, but all I'm going to say is that two big risks. If you use a tool, you may result in infringing somebody else's work. So whoever's providing your AI, make sure that you get some good warranties and indemnities from them to make sure that you can use it safely. But probably more importantly, you might not own the output. So that means anybody can rip off your marketing campaign. So you've got to look to a number of legal rights, there's copyright. You can see that the AI tool has also managed to reproduce, albeit in slightly blurry form, the Getty Images trademark, so you could potentially infringe a trademark. There's a thing called database right, which is a bit technical, I won't get into it. But basically, these are risks that you need to be aware of. We should have an answer, hopefully, in about a month's time as to how safe it is to use an AI tool. But until then, it's basically just be careful. That's the only message. Thanks.
AI, surprise, surprise. And the topic I'm going to talk about is really whether you as a business might look to build your own AI using maybe some open source models, or whether you should buy an enterprise solution. And there are obviously pros and cons of each. With a self-build option, that really would obviously enable the business to build a solution which is really tailored to the business's own needs, its existing processes, and which integrates with other systems. But this will require a lot of time, effort, money, and of course access to the technical expertise. And a vendor solution, obviously, is going to offer more limited customization and most probably will require you to make a lot of changes in your business operations and processes. But on the other hand, it will be available in a pretty short timescale in comparison to building your own model, be tried and tested, and no doubt prone to fewer operational issues. So that's one consideration. The next consideration with a self-build model would be on exclusivity, and an advantage for a brand may well be that you can actually deliver something which is exclusive to your brand, which nobody else has, and that may well be perceived as a real valuable asset to your business. With a third-party enterprise solution, whilst it's not necessarily exclusive, you could hopefully negotiate some right to make customizations to the solution. And you may well also be able to achieve ownership of the IP in those customizations, but presumably there'll be quite a lot of money to pay for that. A middle ground, if you're looking to go down that route, may be to negotiate with the vendor some period of exclusivity over those customizations, when you as a brand actually get a period of exclusivity in return for paying perhaps less money, because the vendor may then, after a few years, for example, make those customizations available to the wider market. Using in terms of the next point, independence, the benefit of a self-build model is that you wouldn't necessarily be dependent on that third party, and the risk of vendor dependency and lock-in will be mitigated. So there are other things you can do, though, rather than spending a lot of money on developing your own solution. So whilst you may not be able to do a lot to influence the vendor's roadmap, you can actually negotiate contractual terms, of course, to manage price increases and to ensure that on termination of the contract, the vendor returns to you the data that belongs to your business in an agreed format, and also that the vendor cooperates in a handover, whether that's to another vendor or back to you for an in-house solution. One of the biggest sticking points, though, when you're building your own model, particularly as a young business, is having access to sufficient data. If you're at the scale of some of the supermarkets we were talking about earlier, then obviously you'll have an awful lot of proprietary data that could be used. You need to make sure you have a lawful basis for using that personal data. But with a younger business, this is likely to be a really major challenge. And the cost of securing licenses from third parties to access their data, if they're willing to license it, will really be significant, and also will take a significant amount of time to negotiate. So using a vendor is obviously going to enable you to access data that they have licensed on behalf of a number of customers at a lower cost and more immediately. And following on from Ian's comments about IP claims and risks, in a self-build scenario, you'll need to make sure that you have done everything you can to mitigate your risks of third-party claims, which will take an awful lot of due diligence. And negotiating with a vendor, you can be, to some extent, reliant upon them for having negotiated positions with third parties, and also they may be willing to take some contractual responsibility for third-party claims. It's unlikely you'll get completely full cover from anybody in reality, because everybody's reliant on insurance and things like that. But there will normally be some opportunity to negotiate some level of indemnity protection, which will be reassuring. Also, the reality is that third parties are probably more likely to bring a claim directly against the vendor than against the brand. So another concern that businesses have when they're using a third party is the risk of their data being leaked via the AI model. So it'll be really important to ensure that there is contractual protection, and also that the model is checked to ensure that the data will be technically separated from others, and that it won't be used to train the model generally, but only the instance of the model that you're using. And then last but not least, the regulatory position. Obviously, it's really important to ensure that that you're compliant from a regulatory perspective, not only to avoid the risk of claims and fines, but also demonstrating compliance can be a really valuable brand asset. So in a self-build scenario, it will be up to the brand to carry out that full legal and regulatory investigation to understand what it needs to be compliant with, and ensure that the business can comply with all those regulations and will be able to comply on an ongoing basis. In the UK, we don't currently have any overall universal framework for AI, so there are a lot of different regulations that will apply in different sectors. And it'd be important for the business to ensure that it's fully investigated, all of those. The EU AI Act, which will be applicable to any business operating in the EU, does require developers to comply with a whole host of obligations. It also does require the deployer, which would be a brand deploying a third-party solution, to comply, but obviously the lion's share of the responsibility remains with the actual developer. So anyway, at the end of the day, I don't think there's any hard and fast rules as to whether you should build your own or buy a solution, and probably it'll be a mix and match approach. So where there is something that would be really, really core to your brand that will bring real value, then you may well want to investigate building your own or heavily customizing a third-party solution. But where it's a business as usual tool, then more likely the decision would be to rely on a third party to help you do that at a much easier and in a more cost-effective way. So I'll hand over now to Robert, who's going to talk about employment.
Good morning, everyone. We haven't got much time, which is good news for you. I won't be talking about AI, much as I love it. And at the break, Paul Beanlands from our wonderful real estate team told me I had to keep it light. You did a really good job of summarising the current economic status in the country, so please bear that in mind throughout this talk. The Employment Rights Bill, for us sad employment lawyers, is the biggest set of changes that have been brought in well over 25 years. There are 28 big employment reforms coming in over the next 2 years. So there is a lot to keep track of. Angela Rayner was the driver behind a number of the changes, particularly on the trade union front. Her resignation, the government has been clear, will not derail them bringing in those changes or dropping them, and we do await a lot of further detail in relation to what trade union, so increased recognition, increased access to your workforce will bring. So we're just going to focus on 2 or 3 of these areas given timing. So the big one, the headline one that everyone talks about, unfair dismissal. Currently, to bring a claim of ordinary unfair dismissal, you need 2 years continuous service to do so. The government committed to bringing in a day one right not to be unfairly dismissed. The House of Lords has kicked that back and said that it should be only apply after 6 months. Many of you will be familiar with the Shrewsbury Convention, so as a manifesto pledge, the Lords should not oppose it again. So we fully expect that to go back to being a day one right, subject to the light touch process that's going to be at some point drafted in some regulations that we will see over the next 12 months. That will give you as employers 6 or 9 months to assess whether someone's up to it or not, and then to go through the light touch process and dismiss them without bringing a claim. If you believe all of that, then good luck to you, but we can see a lot of legislation and cases about, well, was it light touch, was it fair in that time or not? The second one I just want to bring highlight is preventing sexual harassment of your workforce. So last year there was a new duty brought in to take a positive obligation to take reasonable steps to prevent your employees from being sexually harassed. That is being extended under the Employment Rights Bill so that you will need to take all reasonable steps to prevent them being sexually harassed. And the other one that is not much mentioned, but will be a real thing to sort of to contemplate at board level, will be there is a duty that's going to apply so that you will be required to take all reasonable steps to prevent your employees from being harassed on the basis of any protected characteristics, so age, race, disability, sex, etc., by third parties. So you'll need to have a big think. Yeah, I know. It doesn't get much headline in the press, but it will when it comes in, particularly for a number of you in your areas where you're interacting with customers, third parties. So you'll need to think quite carefully about, right, well, where do we think, is Anne more vulnerable, is Charlotte more vulnerable, or is it Ian, or is it me, because of where I work in your business, and then what's your plan for it, what steps you're going to put in place, a bit like the defence that you can run in relation to, right now, to discrimination claims, showing that you've taken steps, you've got policies, you've got procedures, but it's going to be a much more detailed, we're running short of time, Rachel, aren't we? I know. A much more detailed, it's going to be a much more sort of thorough process that you're going to have to be able to point to, rather than just saying, yeah, we did think about it. Well, here's where we thought about it at board. this is where we fed it down, etc., etc. From April next year, statutory sick pay will be payable from day one of sickness, so that will be an increased cost. There'll be no waiting days, and that will be applicable, or sorry, not applicable, or everyone will be entitled to it. So the current lower earnings limit, which precludes a number of people who are very poorly paid from claiming that will go. So it will be an increased cost. We don't like increased cost, do we? Correct. On that basis, national minimum wages. So currently, 18 to 21, you must not be paid less than £10 an hour. Everyone else, it's £12.21. So think on that at lunch. Those are being abolished. So from April next year, that will be, so the £12.21 will be the minimum likely to be increased. So that will be, so anyone that's 18, 19 or 20 in your workforces will be looking at a substantial raise. Mindful of Paul's instructions to me at the break, I've tried to pull together a few things to take away from this very positive and uplifting update. So over the next 6 months, and I borrowed this phrase from one of my other partners who isn't here, so please don't tell Andrew, but a good time to do some cold towel thinking, his phrase, not mine. We heard some really interesting, a really interesting story from Rob earlier. He told me he's a Rob, not a Robert, so it's okay. I'm not being overly familiar. But when the storm came in COVID, how did they react? How did they lead? And I think that's probably for those of you who are in leadership positions in your businesses, then both in terms of your customers and your employees, a lot of eyes will be on you in terms of decisions you take and how you lead over the next 6, 12, 18 months. Rob also reminded us that people don't like change. That goes across the board. It's not just for customers. It's all humans. So brand, reputation, etc., etc. Structure of your workforce. Where will you hire? Which roles? Which will it be in the UK? Will it be somewhere else? How will you? I'm sure all of you have a fully documented and proper performance management process and probation management process, but with the changes coming in, obviously we'll need to make sure those are all being followed. How do you incentivize and retain talent? And the $1 million question: how do you improve productivity? Absolutely no idea on that one, but so plenty to think about. The next slide, which I'm not going to bore you with, but just to say in terms of CCTV usage, which there's been a fair amount of coverage of in the press over the last few months. Anne is your data protection expert, but basically you can do it in an overt way as long as you've carried out a data impact assessment and it's all visible. So for protection of staff and or anti-theft measures. You can also use covert surveillance again in a very targeted and time-limited way where you think there's theft or some other criminal activity going on, and if you weren't to use covert surveillance or CCTV, you'd undermine your chances of finding out the culprit. So you can do it again, as with all these wonderful things. You need to document the process and the thinking behind it. So that is all from me. You'll be very pleased to hear there are some drinks where we'll be hanging around. It's not all actually. November the 25th, please put it in your diaries, the employment conference. I know it's a big week, there's a budget on the 26th, but we will be going into a deep dive on the Employment Rights Bill. We will also be doing a sort of playful grievance where you'll get to see why we had to go into law and not go into acting. And James Baker, for those of you who know him, will be doing a review of the last 12 months and a look forward to the next 12 months, and that could cover absolutely anything. So be sure to come along in person in Sandy Park in Exeter or online, but hopefully see you there, and thank you.